The judge just advised the former president of the penalties he could face if convicted. Count 1, the judge said up to 5 years in prison. Count 2, up to 20 years in prison. Count 3, up to 20 years in prison. Count 4, up to 10 years in prison. The former President Donald Trump, according to our reporter in the room, was leaning forward in his chair, listening intently to the judge as she went down the list of each count and the potential time in prison that someone convicted of that count could face. The judge also read Donald Trump his rights in connection to this case and asked if he understands those rights. Again, Pierre Thomas, this is the kind of moment that reinforces really the weight of what it is we're reporting on here today.
David, there's always that pregnant moment in a courthouse when a defendant walks in and sits before a magistrate or a judge, when the charges are read and the potential penalties are laid out. It's a moment when you're there covering it, you try to put yourself in the position of the person hearing it. And this is the former president of the United States hearing, hey, if you're convicted, and again, prosecutor has to prove his case in court before a jury, but if you're convicted, you could face up to 20 years maximum in prison. Just think about that.
We have just been told, Pierre, that the former president himself said not guilty to each of those counts in the courtroom. Alex Mallon, part of our reporting team there, witnessing this, saying Donald Trump has said in court himself not guilty. Not through his judge, or not through his legal defense team, the 2 lawyers on each side, but himself saying not guilty in that court. But it is stark, John Carl, to hear up to 5 years for count 1, up to 20 years for counts 2 and 3 each, and up to 10 years for count 4.
I mean, you're talking about, these are maximums, but those are all life sentences. You know, now, and maximums are rarely what you would see here. But I want to point out another aspect of the defense, David. Surely there's the free speech defense that they've signaled they're going to make. There's the advice of counsel defense they're going to make. They're going to talk about state of mind. But the other one is delay. Delay, delay, delay. And that's the central strategy, I think, in each one of these cases, in New York, in the classified documents case, and in this case, to delay the proceedings in every possible way in the hopes that he will win the Republican nomination and that he will win the general election, and then he can call it all off.
It's something that has worked for Donald Trump many times in the past.
Yeah, I mean, this has been his strategy since long before he was in politics.
But think about this. If he does win, right, and the New York or Georgia cases continue, because he can't just end the New York or the Georgia case. Those are state cases brought by state prosecutors. He could probably figure out a way to end the federal cases. I think that's pretty clear. But what happens then? I mean, he's president of the United States, and Georgia, let's say the Georgia case hasn't gone to trial, and the Georgia prosecutors are insisting we just still want to move forward to prosecute the president of the United States. I mean, it's a scary thing to think about.
Well, especially because he has shown that he is willing to use the power of the federal government and the power of the office of the presidency to further his own ends. So, I mean, how is Donald Trump, as the now 47th president of the United States, going to willingly and, you know, go down to Fulton County, Georgia, and stand trial?
No, I think that's clear.
I think there's no way.
Right.
So you'll have yet another constitutional crisis.
Aaron Katersky outside federal court in Washington. He's reporting live for us. And Aaron, as we've been reporting here, each count laid out before the former president, pleading not guilty himself in that courtroom.
Uttering the words while standing before the federal magistrate who heard the plea. And former President Trump is used to have people standing before him, but he had to do it, face the judge, and enter the not guilty plea to each of the 4 counts after the judge had read them aloud and after she had told the former president the potential penalties if convicted, a total of 55 years. It's unlikely the former president would serve anything close to that, if any time at all, if convicted of these counts. But it was a stark reminder of the consequences. The former president also had previously to enter his age, 77. He had to remind the judge of his middle name, John, when he first appeared before her. And now this proceeding should be winding down. We may hear when the next date is before the district court judge that will be ultimately hearing this prosecution. And then the former president is expected to quickly depart this courthouse and return to Bedminster, New Jersey. But David, just an extraordinary proceeding in 3 separate cases in 3 separate cities. The former president has pleaded not guilty to each and every charge he's faced.
Aaron Katersky outside that courthouse, the federal courthouse, just steps from the Capitol in Washington. We're getting a readout of what's described as a somewhat awkward moment inside that courtroom. When the former president was asked to say his name, he apparently stood up and walked over to a microphone at the counsel's table to say his name. It was then the judge said he didn't have to stand. The former president walking back to his seat, sitting down, and then proceeding to say his name, his age, pleading not guilty himself. We are learning terms of release at this point, and John Carl aptly pointed out a moment ago that, again, he's not handcuffed. There's been no mugshot, but he's, in essence, under arrest in that courtroom. They have just agreed to conditions of Donald Trump's release, and let's bring in John Santucci. What's the team learned on that, John?
David, we're learning from our Alex Mallon and Mike Levine that are watching this in real time that the prosecution and the defense have agreed on several conditions. 1, Donald Trump must not violate any other federal or state laws. 2, Donald Trump must appear in court as required. Obviously, we'll be yet to see a calendar on this case, David. Trump must sign an appearance for bond. And as one of the prosecutors put it, he must not, quote, communicate about the facts of the case with anyone Trump knows to be a witness, except through counsel or in presence of counsel. And David, that one is duplicative to the other case that was brought by special counsel Jack Smith, the document retention case. Witnesses that are involved in that case cannot talk about the case with Trump. We see here in this case now on the efforts to overturn the 2020 election, same thing. Donald Trump cannot talk to any other witnesses that are known to him and his lawyers. And that is obviously, as we talked about, David, several weeks ago here with you, that's going to be a problem for Donald Trump, because the one thing we all know Donald Trump likes to do is talk about his current situation. He talks about these cases, talks about what could be next. How is this playing for me? It's a phrase we have heard many, many times over the years from Donald Trump. That one in particular, David, that is going to be a problem for Donald Trump, but if he wants to avoid any further issues, he's going to have to stick to it.
So for an example, Dan Abrams, if Donald Trump wanted to talk to Mark Meadows, let's say, he can only do it through counsel or in the presence of counsel. He can't pick up the phone and call Mark Meadows.
To talk about
this case.
Anything related to the case.
That is not surprising.
Right, not surprising, but remember, you still have to get caught, right? I mean, you know, I mean, I hate to phrase it as if it's so cavalier, because it's not. But, you know, these are the sorts of orders that happen that as long as someone doesn't report it, as long as he doesn't say it in public, as long as the witness is still on the same page with Donald Trump, no one's really gonna know about it. But with that said, when it comes to some of the witnesses who are not currently, you know, at Mar-a-Lago all the time, people who he's not regularly talking with, it's a clear statement from the court, you better not engage in any witness tampering. And even more than that, you just better not talk to them about it at all. I mean, think about it. In a trial, very often witnesses aren't even allowed to sit in the courtroom when other people are testifying because they don't want it to impact their testimony, right? So witnesses are often asked to leave the courtroom or not allowed to watch the proceedings because they don't want the proceedings to influence their possible testimony. You have a similar issue here, which is, put aside even witness tampering, you just don't want witnesses improperly influenced based on conversations about the case.
We're just hearing, Dan, that a hearing before Judge Tanya Chutkan, who is the judge who will take over the case from here, the Obama-appointed judge who has overseen a number of January 6th cases, has handed out a number of stiff sentences to people involved with January 6th. She will preside over the trial. The hearing is scheduled for August 28th, 10 a.m., so the end of this month. The latest of 3 dates offered as options. So again, the magistrate overseeing today's hearing, the The latest date of the 3 dates offered as options from prosecutors was selected. Prosecutors had wanted the hearing to be earlier, but again, the next date, key date on this calendar, August 28th.
5 days after the Republican debate in Milwaukee.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.